founders of Savannah Heights Cement. They entered into contractual and agreement-based businesses to start a factory. One of the partners, unknowing to the other shareholders, forged documents and went and secured loans from several countries, from South Africa and from local banks in this country. This matter went to the High Court. It has been on and off in courts from 2010. It started as a commercial dispute where our clients were temporarily removed from the running and managing of the company, and an interim board ordered by the court to manage the company. We have no dispute with that because that was a court sanctions act. Our client fought and those orders were vacated. Of great concern, our client reported this matter to the DCI in 2010. Investigations have been at the DCI for all that time. The evidence was overwhelming. The file was never taken to the ODPP. Later, the file was taken to the ODPP and a charge sheet was approved. The accused appeared before court and took plea and has never appeared in court any other time. The accused filed a matter that stayed the proceedings in the lower court through a constitutional petition before Justice Mwamuye. Those orders were vacated. He filed a revision of Justice Mwamuye's orders. The matter was in court today. That's why we have left with our client. The highlighting of submissions in regard to the revision is coming up on Thursday. He has also filed for revision before Justice Muya. And that is why we are before this media, that serious anomalies within the judicial process is completely prejudicing our client. One, the magistrate's court has not issued warrants for an appearance of an accused person. Every time he's claiming, the advocates are claiming he's out of the country. This matter has been decided that the proceedings in the criminal court, the magistrate's court, must proceed through the decision of the learned Judge Mwamuye. A third judge of concurrent jurisdiction cannot purport again to sit over a matter where another judge has sat and made a decision, but the accused person must proceed with the hearing of the trial. We have filed a serious application informing the learned Judge Justice Muya, but that is forum shopping, and we believe the judge is not aware that this matter had been decided by Justice Mwamuye, and still it is before Justice Mwamuye for review. Our client has tabulated very well the complexity in this matter. The learned court gave two distinct orders. One, to the DCI to supply the complainant with the witness statements and documents that they wanted. To date, the DCI has not. And yet the DCI and the complainant are acting together. The complainant is not an accused person. Any document in possession of the DCI is document to be in possession of the complainant. We know very well the DCI is trying to protect some banks that gave money illegally through forged documents. We shall be moving to sue the DCI for him to release the documents to allow the complainant pursue those banks that are complicit in this matter. Another order was issued to the governor of Central Bank to supply the documents for the complainant to use in his defense and to seek legal redress. The governor has never done that. We have written to the governor and we have written to the DCI, giving them 24 hours to supply us with those documents the court ordered. We shall be making an application for them to be summoned to court with a view of being cited for contempt. This matter is a matter of great public interest. Banks have a duty to protect the interests of their customers. Banks have a duty to only loan to entities based on genuine documents. We are ready. This matter is coming up on Thursday. We have agreed with my client that we shall be briefing the country as and when we are in court and what is happening. Our client is also concerned about his safety, considering that this matter has now become public. His life is in danger. He can't be eliminated because the banks our client is taking on are serious banks in this country. The amount we are talking about are colossal. It is in terms of billions of money. This is the matter that has taken off from 2010. We are now in 2026. What is the fate of entrepreneurs who have invested? My client, our client, is a retired senior citizen. He hopes to have closure of this matter before his creator takes it. So, as we have said, I'm joined by my good brother, the advocate who has been in this matter. He can also highlight on the issues because he has institutional memory of how this matter has started up to where we are. Okay.
Everyone, my name is Vishigo. I've been representing my client for quite some time. And as my colleague says, this is a matter that is deeply disturbing. We are greatly concerned as to the nature of and how the matter is progressing. As my colleague has said, there are criminal matters that have emanated from these proceedings, as well as civil proceedings that are currently ongoing. Our main issue and our main concern is that the main perpetrator has not been able to attend to attend various court sessions, even as the matter is progressing. And it is our hope, and even as my colleague joins me, it is our hope that our client will get to have his day in court, and he will be able to prove that what has been done to him and his company is something that should not be allowed to happen to anyone else in this country. I think being that the matters are still live in court, I think I will leave my comments as short as that, but we do say that we are hopeful and we remain hopeful that the courts shall be able to help out our client. Thank you very much.
Accused in court, in the criminal court?
In the criminal matter, there are two accused persons. One is an American national by the name Charles Hill Jr., and the other one is Benson Sandendeta.